Thank you, Mr Chairman. I appreciate the opportunity to take a brief call on the Search and Surveillance Bill. And on Part 4 particularly, it's worthwhile recognising that Part 4 is to do with the general provisions in relation to search and surveillance powers, and possibly to remind the last speaker of the purpose of this bill, and I crave the indulgence of the Honourable Charles Chevelle, because I'm actually going to make a couple of words from the introduction here, just reminding Mr Clendon that we are dealing with search and surveillance powers, inspections powers amended by the bill, go across 69 acts. 69 acts. So it is obviously going to deal with arcane officers to do with veterinary medicine and fisheries, etc., as he pointed out, and it is intended as a comprehensive reform of search and surveillance legislation. And Part 4 is a good case in point. It deals with consent searches, application for search warrants, issuing of search warrants, search powers, detention of persons at the search scene, and of course we have heard that it deals with examination orders and production orders and surveillance. I'd like to come back briefly to examination orders. And this bill does have an examination order regime. We have heard quite exhaustively from the opposition how the Serious Fraud Office currently has the power to apply for an examination order. And we heard from the Minister that this, in fact, is a power that they've had since 1990. The bill will also allow the police to apply for them. Now, we know that examination orders are recognised as a serious power and additional safeguards will be in place. Now, what will these safeguards be? Well, the police may apply for an examination order in a business context to investigate an offence punishable by 5 years in imprisonment. 5 years of imprisonment, in fact, Mr Chairman, or more. Examination orders allow the police, people who acquire information in the course of business, such as accountants, to cooperate with the police. So they can cooperate with the police without being guilty of breaching professional fiduciary obligations. In a non-business context, the examination orders may be applied to investigate serious fraud punishable by 7 years or more imprisonment. Now, it's important in response to some concerns, and I do acknowledge how open-minded the Minister has been to concerns that have been raised, and she's specifically mentioned Honourable David Parker and Charles Chevelle with some of the help that they have given to this. Some other people raised concerns about the impact of this on civil society and the right to protest. So the 7-year threshold in non-business context means that examinations orders are not available to investigate such crimes as protesting, trespass, disorderly behaviour or unlawful assembly. Very good point, I thought. In addition, only a judge can make an examination order upon application from a police officer of the rank of police inspector or above. So this is a tangible acknowledgement of the seriousness of this. This ensures that examination orders do not become a routine tool for investigation. The privilege against self-incrimination is something that was raised by a number of speakers, and this has been the subject, as we've heard, of a particular SOP number 12, where we have dealt with this, and we are particularly keen to defend the media impartiality and the media sources. A key change has been to significantly improve journalists' ability to protect the identity of their sources and enhances their journalistic privilege. This has been made in recognition of the media's role in a free and democratic society and the need to protect that role and preserve the important principle of media freedom. At the moment, the media cannot prevent material from being seized during a search and therefore viewed and accessed. This SOP will make that a lot less likely to occur. The bill will allow journalists to claim privilege over information contained in documents, preventing the documents from being searched. The documents would then be secured and taken to the High Court for safekeeping, with the claim of privilege can be determined. So effectively, Mr Chairman, the Search and Surveillance Bill recognises journalistic privilege and provides greater protection for journalist sources. Journalists can also refuse to answer questions.
I call the Honourable Leanne Dalzell.
I couldn't really resist joining the debate.